A very warm good evening, everyone. I am Sarab Lamba, Research Associate at the India Justice Report. On behalf of the entire IJR team, I extend a very warm welcome to each one of you present here today this evening. As a lot of you already know, the India Justice Report is a collective of 6 civil society organizations: the Commonwealth Human Rights Initiative, Common Cause, Daksh, Center for Social Justice, Prayas at TIS, and Vidhi Center for Legal Policy. We assess the capacity of the states to deliver justice, which is measured against their own statutory mandate and using only government data. Today, I am very happy to welcome all of you at the formal release of the Consumer Justice Report 2026. This is the first ever comprehensive assessment of the institutional capacity as well as the workload of the consumer dispute resolution commissions at the state as well as at the district levels. Before we begin, may I request the members of our steering committee who have been partners in our journey at IJR to kindly join us on stage. The one on time is Miss Leah Verghese, Research Manager at Daksh. Welcome. Two of our steering committee members, Dr. Orgo Sen Gupta, who's the founder of Vidhi Center for Legal Policy, and Dr. Vipul Mudkal, Director at Common Cause, are currently stuck in traffic and will be joining us shortly. May I also request Ms. Maja Daruwala, Chief Editor of the India Justice Report, to join us on stage, and Mr. Valay Singh, Lead of India Justice Report. Three other members of our steering committee could not be here with us this evening: Mr. Gagan Sethi, co-founder, Center for Social Justice; Mr. Venkatesh Nayak, Director, Commonwealth Human Rights Initiative; and Professor Vijay Raghavan, co-director at TIS Prayas. Finally, I am extremely happy to welcome on stage our chief guest for this evening, Justice Sanjay Kishan Kaul, former judge at the Supreme Court of India. Welcome, sir. Sir, if you may please join us on stage.
Then I think we do the release
Not
call
now, no?
Pushpa and everyone also on
अभी कर ले release?
करवा दो.
Okay.
As you wish.
No,
Yes.
no, that,
So
that's
that's after. This is the formal release.
Yeah, sure. Valay is only pretending to be a judge.
We now move to the formal release of the Consumer Justice Report 2026. May I request all of our distinguished guests on stage to kindly join us for the release, along with which I would like to invite members of the IJR team, our partners from How India Lives, Professor Bejon Kumar Misra, the consumer expert, along with our panelists for the evening, Ms. Pushpa Girimaji, Mr. Rajrishi Singhal, and our steadfast mentor, Justice Madan Lokur. Please, sir, we request all of you to join us on stage for the formal release.
Yeah, I opened it for you. Otherwise, you'll never get it open. Thanks, Vijay. Come here, Pushpa.
you can go that side.
Hello, sir.
Ma'am, how are you?
Very well, thank
To
you.
meet you.
Good to meet you, indeed. Have you got a copy? Okay, well, you better start opening it because it's damn difficult.
I know. Double wrapped.
I think the thing. Oh, God, it's just too hard. Good luck with that.
You do the brutal way.
Thank you. Now, to present the key findings of the report, I invite Ms. Maja Daruwala, Chief Editor of the India Justice Report. Thank you.
Good evening, ladies and gentlemen. Can you hear me? Yeah? Great. So I'm looking directly at Justice Lokur for inspiration this evening. So, thank you for being here. I know it's very I know that many of you have wanted to be here and be here on time, but Delhi traffic will defeat us no matter what. So, this is the second, you know that the India Justice Report produces a report on the capacity of the Indian justice system every 2 years or nearly every 2 years. Now, this is our second report this year. Can you hear? Are you all right? Okay. So, this is our second report this year. Earlier this year, we launched a report on juvenile justice. And this report is on, as you can see, consumer commissions. So why did we break with our usual criminal justice focus to look at consumers? And this was because, for many reasons. One is, of course, plenty of it is obvious. One reason is because we are all consumers. And consumerism, in the best possible way of people having the purchasing power to consume, and is going forward very quickly. And this also benefits the country economically. There's more purchase, there's more manufacturing, there's more goods and services. So all of these goods and services are also regulated. They have standards. So we wanted to see whether, when these standards are broken, or is there a place where you can go for redress. So our collective of 6 decided that this was a good moment for us to be looking at this. So there is a structure, and do you want to put up the structure? Yeah. There is this structure which is nationwide. It's a 3-tiered structure: national, state, and district. And you can see the numbers on that side. Each state has one, then there are the districts, and then the division of labor is between all of these 3 under a pecuniary jurisdiction. So if you have a claim of more than 2 crore, you go up there, otherwise below, and then below that. Now, the idea of this whole thing was that we should have a friendly, easy to access, and local, a local forum where people could go. So, and then the law also had changed. As consuming increased, the law also changed because the market changed. The market became digitized, online, very complicated, and it also spread to many small jurisdictions. And these were first-time consumers. So to help them, this tiered system was brought in. The first consumer law came in 1986. But then as the market changed, we went to 2019, where e-commerce, product liability was also added into the law. The Central Consumer Protection Authority was added, more members were made into the commission, and also there was another layer added by bringing mediation into the law. So with the expanded law, in short, it modernized consumer protection and to fit into the changing marketplace. Now, it has been nearly 40 years since the first law and several years since the 2019 law, and it is also World Consumer Day on the 15th of March. So it seemed exactly the right moment to ask this simple question. Are the institutions actually equipped to deliver what the law promises? So we started to look at the usual things that the India Justice Report looks at: budgets, human resources, infrastructure, diversity, and So first, I should point out that we did not rank every single commission. We usually assess and rank, but we did not rank every single commission. We ranked the state. Why did we rank the state? Because the state has the responsibility to provide the consumer with a fullest architecture from which he can benefit. So what did we measure in order to arrive at the ranking? We measured whether there were consumer commissions in every district, whether state commissions had enough members and presidents, whether budgets were being fully utilized, and whether cases were being disposed of in the statutory time frame, whether the minimum gender requirements were also being met. So there was a lot more we could have measured, but naturally we had to restrict ourselves to the metrics that could be compared, and data was, as always, a problem. There is the data that is put out and data that has to be asked for by right to information requests, which are inevitably partially provided, late provided, not provided at all. So, but at the same time, I want to say that like everything we do at the India Justice Report, all of it is government data. There is no other data that we use. But outside of the ranking data, the data that we use for ranking, we also wanted to put forth before the people who will use this report that there were trends. How many vacancies were there over 5 years? What was the gender diversity over 5 years? What did the budget allocations look like? Were the filings increasing or decreasing? How were they being used? The other thing that we did, which I think that most people will find very interesting and also very useful for the consumer who's trying to decide whether or not he should file a case. And supposing he's in Lucknow, then shall I file a case in Lucknow? He may like to look at the dashboard that we have created. It's an interactive dashboard which draws on nearly 29 lakh consumer cases that have gone over 15 years. And what does this do? It looks across this to see what are the sectors that are most litigated. The most litigated sectors are insurance, housing, banking. And these are really important, and this is why consumer commissions should really work well, simply because these are sectors that affect the everyday life and happiness, and their outcomes are so important. And they, apart from another category called others, These three sectors make up almost half of the filings that have been made. Now, this is an interactive dashboard, so you can go and pick, say, Valay here has got his own manufacturing called Valay International, because he's never local. So you can look and see, this is the entity. How many cases are there against Valay International? And so you can also look sector-wise. You can also look for your own commission. So it's really a very helpful aid to somebody who's thinking about how to do this. But I must get back to the ranking, because the ranking is always at the heart of our work. And where are our rankings? Here are our rankings. Oh, sorry, I can see it over there also. Sorry. So as you can see, I'm not going to go through all of the rankings, but we ranked all the states. Andhra Pradesh, Madhya Pradesh, and Rajasthan emerged as the top states. And among the smaller states, because we always divide by population, the smaller states are those that have less than 1 crore. So we ranked them against the statutory benchmarks that they had. And it's interesting that even these states that came top could not reach, we rank everything against 1. And then we say the best in class will get 10 and the worst will get 1. So in that ranking, what we found that not even one of them, I think except Andhra, managed to just go over 6.2. That's 6.2. And Manipur, 1.7. So you can discern from that what happens. And what did we find? So, as I said, none of the states, there was slippage in one or the other indicator, even when they were doing well on others. So every state is supposed to have one state commission, and indeed they had. And many had regional benches. But you'll be regional benches and district commissions. District commissions, that was a difficulty. Because, really? Well, what do you say? Okay. So district commissions, because we started late, I guess. So anyway, so district commissions, 1 in every 10 didn't have. But what was didn't have a commission. So where is this poor consumer supposed to go? So now, the bane of these commissions is, of course, vacancies. They are supposed to have a president, and then they are supposed to have members. 4 members at the state level, minimum of 2 members, and these make up the quorum. You have to have a minimum of 2 to even make a decision. But against the parliamentary question on this thing, on vacancies, you are finding that there is 17 out of 35 commissions don't have a president in 2025. So sometimes you're not even going to have to make a quorum. And of course, the story is and during a 5-year measurement, you find that some years there were presidents, other years there were not presidents. The years that had presidents didn't have members. And so it's not difficult to see that they are going to have huge amounts of arrears. They have the same kind of arrears as in the ordinary mainstream. Large arrears growing all the time. Now, there is a benchmark that says that you have to decide on the cases between 3 and 5 months. That's the limit for your decision. The average, when we looked at the dashboard, which was Convener at that time, we looked at it, we found that the average, if you take it across, is 600 days. So you calculate what that does. Naturally, there are arrears. Naturally, the arrears are going to grow. And in the absence of a president, it's not just a vacancy, but it creates a functional block, a functioning roadblock. The president is supposed to oversee the district commissions. He's supposed to oversee their performance. He's supposed to allocate money. He's supposed to make decisions. Without him, you can't do very much at all. So I'm just thinking what I can leave out and what I can keep in. Money. These commissions also are running on very little money. Of the 20 that replied to our RTI on this, we found that if we calculated per head capita, the 20 who replied to us represent about 75% of the population. And the expenditure per head on the back of an envelope is about 2 rupees, 2 to 4 rupees. So you're not, I don't know what you're going to get for that. But then there's the staffing. The staffing has the same problem as the ordinary criminal justice system or civil justice system. About 20% approximately is that. And all of this has great consequences. And the staffing is also erratic. For instance, Jharkhand has got 16 staff sanctioned and 65% vacancy. On the other hand, Rajasthan has got 130 staff sanctioned, but Maharashtra and other large states who are as large as Rajasthan or even more population have staffing strengths of 51, 31, 36. So all this function, it creates a big dysfunction. So I'm going to stop over here and say that one of the things that we noticed was that the filings are approximately a little less than 2 from the answers that we got on our RTI. We found that the filings are about 2 lakhs, a little under 2 lakhs a year. Now you think of the vast population and the vast consumers, number of consumers. This doesn't indicate that things are going smoothly. Indeed, there are different ways. There are internal mechanisms that manufacturers, etc., use to address complaints. But it isn't a sign that things are good, but rather that there is a kind of tiredness, exhaustion, inability to access, frustration with a system that can't be seen, is seen not to be able to function. So I don't want to leave you on a sort of sour note, but just to say that this is an important moment for the people who are sitting here and for ourselves, in that this is the season in which the government is looking for amendments and looking for suggestions to improve what there is there. My point is that none of it is rocket science. Just get the benches, appoint people. There's been a battle in the court for appointments. Been going on for 20 years. I think Justice Kaul mentioned that he was part of one of these long cases. So that in itself is holding up stuff. But it's not that there isn't a formula, but there's just no desire to sort it out. You've got to fill in the stuff. You've got to fill in the benches. You've got to make it easier. You've got to perhaps not throw so much money at it, but just make it work better and simpler. Because right now, the system has become so degraded that it doesn't seem to be reasonable to even have a second system. Mediation, which was brought in, is now, there are minuscule number of, literally in the hundreds, that go to mediation. And mediators are not available. And we are not, we are talking about the main system, the main frame of the system. We are not talking about the ancillaries which are not there. For instance, if you've got an extremely technical matter before you, you have to send a part for testing. Well, where will it go if there's no local ancillary attached to the court? And so on it goes. The main bottom line is that these are matters these are complaints about shelter, savings, security. And they are not being met in a special forum that was made just for this. Thank you.
Thank you, ma'am. We now move to a conversation around what these findings actually mean in practice, which is the title of today's panel discussion, Jaago Commission's Jaago, a take from the Jaago, who have been now awake, but it's the Commission's whose time it is now for an institutional overhaul. For this segment, may I please request our distinguished guests on stage to please join the audience while I invite the panelists on stage. Thank you so much. May I also request the volunteers to please remove 3 chairs from the stage and arrange the stage for the panel discussion. In the meantime, in the interest of time, I'd also introduce our panelists. Our first panelist is Ms. Pushpa Girimaji, an author, columnist, and one of India's foremost voices on consumer rights, law, and safety. For over 4 decades, she has widely written weekly columns that have consistently championed consumer empowerment, making her the only journalist in the country to have sustained such a long-running public advocacy. She is the author of Consumer Rights for Everyone and a recipient of several awards for her work, including the Nari Shakti Puraskar, the highest civilian honor for women in India. Welcome, ma'am. Our next panelist you're arranging this, is Professor Bejon Kumar Misra, again one of India's foremost consumer rights advocates and our guide during this study, with over 4 decades of work in consumer education and advocacy. He is the founder trustee of Consumer Online Foundation and has played a pivotal role in shaping the landmark legislations, including the Consumer Protection Acts of 1986 as well as 2019. He's also spearheaded the iconic Jaago Grahak Jaago campaign. Welcome, sir.
Thank you. Thank you.
The third panelist yes, sir, we're just arranging the lead tags. The third panelist is Mr. Valay Singh, the lead of the India Justice Report. Over the course of his professional journey, he's worked as a journalist and as a media and policy consultant with numerous Indian and international civil society organizations. Valay is also a published author and regularly writes for Indian and international publications. Welcome. This session will be moderated by Mr. Rajrishi Singhal, who is a senior journalist, public policy analyst, and an author. He has served as the board member at the Advertising Standards Council of India, the executive editor at Economic Times, consulting editor at Mint, and the head of policy and research at a private sector bank, before moving into independent consultancy and policy analysis. Sir has joined us all the way from Mumbai here, and we're very grateful to have you, sir. Welcome. We're at 7. Over to you, sir. Thank you.
Thank you.
Hello, good evening, everybody, and thank you for joining us. We're running a bit late, so I'm going to keep this a little brief and snappy. As everybody here spoke about consumer justice, and so just to reiterate, as a concept, it relates to erecting regulatory, legal, and administrative structures or mechanisms to protect consumers against unfair trade practices, unsafe products, and dishonest business conduct. A critical component of that justice system is establishing institutions and mechanisms for delivering fair and timely redressal. The Consumer Justice Report 2026 tries to figure out how that system has worked. I have some eminent panelists with me here, and we'll ask them questions about the findings of the report, as well as touch upon some broad issues that relate to existing regulatory and legal framework for consumer protection. So let me dive right into it without wasting much time. The first question is to you, Valay. Ms. Maja Daruwala outlined the findings of the report. Can you tell us what inspired you, what provoked you to look at consumer justice?
Thank you. I was hoping that I'll be a blind spot and you'll go straight away to the most senior people. But at India Justice Report, our philosophy is to try to mainstream the discourse on justice delivery at large and reposition and keep positioning as a essential public good. However, only talking about the criminal justice system has certain limitations. So from a strategic point of view, we wanted to cover areas as a group that also speak to different and probably more influential audiences. And so we came to consumer commissions. Of course, we knew that this was going to be the 40th year of the enactment of the first act. We had great supporters when we first started discussing this idea who are in the system even today. And we realized that while the country's consumer market and consumption is growing so much, we wanted to see and show how much is being put back into redress, because it will, in the end, it will flow back and hurt even consumption and the economic growth.
Right. Thank you. Yeah. So Pushpaji, one of the findings of the Justice Report, Consumer Justice Report, that comes through vividly is the glaring lack of capacity. And almost all is a glaring lack of capacity at almost all levels. How do you expect the consumer justice system to function efficiently, effectively, fairly when it's so structurally hobbled?
That's why obviously it's not functioning well. In fact, it's supposed to deliver justice. Decide cases within 90 days, but it's only, from the beginning I've been seeing, only about 24 to 30% of the cases are decided within that time frame given under the law. So it is unfortunately not working the way it should, and for somebody like me who's been associated with, a campaign for this law, everything, it's really very unfortunate. In fact, there have been earlier reports of Indian Institute of Public Administration, I think 2004, 2013, 2020, which has talked about, all these reports have talked about the problems with the consumer commissions. And now this report only reaffirms what they all have said. And also what is very sad is that even after 40 years, since the 1986 law came into being and consumers got this, their rights, we continue to be in the same position, and that is really sad. In fact, Common Cause, Vipul is here. I remember when the consumer courts were, when the Consumer Protection Act first came into being, the states were unwilling to constitute the consumer commissions. So much so that Common Cause, Mr. H.D. Shauri at that time, he filed a case before the Supreme Court, and eventually, and even then nothing was happening. Finally, the Supreme Court threatened to put the secretaries of state governments behind bars. Only then they started the process. So you can just imagine the low priority that they give to the consumer justice system in this country. And we see that reflected throughout, in all these years, and which is very sad. And I do find that the Consumer Affairs Ministry at the center goes on every year. They call meetings and then ask them and then look at these reports. And then, unfortunately, the state government say, yes, we are going to do this, we are going to do that, and then, but again, it's back to normal.
Professor Misra, is this just apathy, or do you think these rising vacancies are a direct consequence of the Supreme Court, intervening at some point and, laying down strict conditions for recruitment of presidents and members? Is this the way of, is this states reacting to a Supreme Court intervention?
No, you see, good evening, everybody. Good evening. Lovely to be with you all. Yeah, it's on. Yeah. You see, the state governments, I mean, this is my personal perception. I visited almost all the 36 states in the country. I find that consumer protection is of least priority, number one. Number two, they are not accountable to anybody. I mean, nobody can reprimand them if they don't do something. Even the Supreme Court has tried several occasions, suo moto, investigation, Justice Pasayat's report, all are lying in the Supreme Court. Supreme Court commissioned them, by the way, funded by, again, Consumer Welfare Fund. They are using my money and then they are showing eyes to me. They just don't want to respond. I mean, I fail to understand how the constitution of the country works. I mean, which is very clearly
Yeah, so that's what my question is. Why? Why do you think, what is the reason behind this
No
apathy?
accountability. There's no transparency. You seek a data, you see how you can, you'll have to really work very hard to get that data. Whereas many people are employed to do that. I mean, they are bringing in technology, they are paying huge sums of money to the state government to upgrade their capacity, to upgrade technology. All this is happening. But public money is being spent or even not spent. We don't come to know there are 18 states who have taken money and till date they have not given utilization certificate to the central government. And central government is refusing to give further money because they are not giving utilization certificate. Now look at that situation. So for everything, do we need to rush to the Supreme Court? They've got many other important things to do.
Yeah. You want to jump in, Valay?
To say that we actually asked the Central Consumer Protection Authority whether they have received the UCs, how much funds they have released, and a whole bunch of other questions. And Professor Misra is right, the data is very difficult to, it's almost like prying it out bite by bite, not even bit by bit, like bite by bite. So I just want to add that.
Yeah, okay. The other data point that comes through in the report is the low level and unconscionable level of gender diversity, including from so-called advanced states. The state where I live, Maharashtra, there are only 8.3% women representation across the entire 2 tiers of the redressal system. Assam is even worse, it's 7%. On the other hand, you have Karnataka, which has 43% women representation across their commissions. That's not really 50% or more than 50%. It's not exceptional, but it's better relatively speaking. But here's what I found most interesting. The data in the report clearly shows that Karnataka's level of clearance is very high, and they have very low pendency rate. Now, I know I'm cherry-picking data here, but do you think, well, since you've been the mastermind behind this report, there is correlation between gender diversity and high clearance rate and low pendency? Do you think there is a causality there? I mean, it's speculation, but it's worth making this speculation.
Do you think I can give an honest answer?
Yes, please.
Yeah. Okay. Well, I think first on a lighter note, if you look at it, the India Justice Report itself, we have very high efficiency, and most of our team, they are women. So I think, yes, women are better administrators, and they are probably more committed and efficient. But no, on a serious note, I think we cannot really draw that conclusion, because we also have evidence that some of the members are appointed because of political considerations, or it's more like a rewards and recognition scheme running in almost all states, also at district levels.
Yeah.
So I don't think that's a fair scientific conclusion to draw, but in general, I think I completely endorse your analysis of it.
Pushpaji, you would like to say something?
Well, I would say that, it's good that there are more number of women. And in fact, the whole idea initially in 1986 law, when they said there should be a woman member, the idea was that people should come before these courts with their complaints on their own without the help of lawyers. And they felt that presence of a woman, they somehow felt that would give complainants some kind of a reassurance, particularly women. Today, a large percentage of consumers are, 50% of consumers are women, and in fact, now the statistics are saying much more. There are more women who take decisions, in terms of purchasing and stuff like that. So it would give them that confidence and help them. But unfortunately, states are not really filling up those posts. I think in many places, they don't even have probably, he will be able to correct me if I'm wrong, but maybe many of them don't even have one woman over there, which is very unfortunate.
I'll add, it's not a favor to anybody, it is in the act. So one among the president and the 4 members should be a woman. It's a simple benchmark that they have to meet. In the last 5 years, only 3 commissions had a woman president. The number of women members is also declining. So I think we can clearly see a pattern there, while in the district judiciary, the numbers are doing well when it comes to inclusion on gender basis. But over here, you don't see that happening. While at the same time, companies are targeting the women consumer in many of their product categories.
Just one, no, I didn't mean it as a favor. What I meant was it was mandatorily given in the law for a certain purpose at that time.
And
Unfortunately, even that minimum is not being met.
Yeah, absolutely.
Yeah, if I recall, because I was involved while drafting the first draft before it went to the government in terms of taking it to the parliament. The whole purpose was that a message should go, and the women representative has to be a person of eminence amongst women who should be nominated as a member of the district commission, and also similarly state commission and national commission. So the whole idea was to give a message that we need women to get engaged in this redressal mechanism, which is for the first time coming to the country, which would be different to what was existing in terms of the judicial delivery system in the country. Because the Consumer Protection Act 1986, and I still remember, Bihar was the first state. Can you imagine? Bihar was the first state in the country to have the first state commission implemented in 1987. Now, why did Bihar have that? And did that? Again, because, of the activism of the civil society, which made Bihar, and Pushpa is right, and I still recall how Common Cause fought before the Supreme Court and then got an order after a great amount of, effort, resources. They were able to get that order from the Supreme Court to make the states implement. But what I'm trying to say is, again, it all depends on the state's leadership. And I still recall in Bihar, the state commission started functioning from the veranda of Justice R.N. Thakur. And when I met him, and I said, "Sir, what a great thing you have done. You started this from your veranda." And he said, "Why wait? Such a great law the government has brought in. Why should I wait for Lal Batti and peons and chaprasis? I have to start from that veranda." And they started hearing from his veranda of the residence, where retired Chief Secretary K.K. Srivastava and Rama Devi, one of the freedom fighters, were members of the State Commission. I still recall.
So, you're talking about, say, individual leadership and initiative actually pushing this. If that was so, the report also talks about how there has been a tepid response to the mediation mechanism, right? And it's across states mostly. So, again, why is that? And what can be done to remedy that?
You see, I don't know whether you all have read that mediation chapter. You see,
In the Act?
In the Act.
Yeah.
If you read the mediation chapter, it's mockery. I mean, you are telling the judicial system to identify mediators and go to a mediator, and the judicial system, the District Commission and State Commission is saying, I would identify those mediators and I will send those cases for mediation from the District Commission. Whereas it should have been a insulated, independent, neutral body which should have been given those kind of powers, which should have done the mediation on a much faster track, rather than being directed by the State Commission and the District Commission to do mediation. Now, it's a mockery of ADR, in my view. Again, it's all my personal view.
Right.
What I want to share with all of you is, I get very anxious to understand how did they frame that? Where did they get those kind of concepts? That the court will direct who is going to mediate. The mediation should come in a manner that where the provider is unable to give the resolution to the dispute, there should be a mechanism which is independent, and we know and we trust that system, and we go there to mediate.
So you're saying it's not organic, right? That's why. So Pushpaji, do you like to add here something?
Yeah, what I would like to say is, the mediation as it exists, also with the Mediation Act 2023, they brought in some changes in the Consumer Protection Act also to facilitate mediation. But my view is, I don't agree with the court-sponsored mediation. Mediation should be pre-litigation option. It should be an option available to consumers before they go to the consumer court. There should be a mediation facility, and so that if they want, they will first go there, and then subsequently, if that fails, they can go to the consumer court. On the other hand, if you talk about court-sponsored or court-suggested mediation, what happens is that by the time a consumer reaches the consumer court, by then he is already exhausted, he is angry, he or she, and they do not want to go for a compromise. They would rather get better compensation, and they want some kind of a punishment to be, they want the manufacturer or the service provider to be punished and have better compensation. So they are not in any mood to go for mediation. So that's the issue. So in fact, even in 2014, I was on that committee where we looked at amendments to the Consumer Protection Act. At that time also, I was totally against bringing in a chapter on mediation. I was arguing that, because we already by then had mediation and it was not successful. So I still feel that it should be a pre-litigation option.
You're right. But if you look at the Consumer Protection Act and you have that on one side, and then you have many regulators creating their own, redressal mechanism, like say RBI's ombudsman scheme, which has a lengthy, protracted process. Now, for an ordinary citizen, it's a bit like a morass, right? I mean, like a quagmire. How do you navigate through all of this? If I have a problem with a bank, do I go to the redressal system? Do I go to ombudsman? And it takes a long time. And all of these processes actually mimic the civil justice system, which makes it even more difficult for the ordinary person to navigate. Do you have an solution to this?
You're asking?
Yeah, to you.
Well, I would say that, consumers have that choice. They can go to the ombudsman, insurance ombudsman, or a banking ombudsman, depending on the kind of, the nature of the complaint they have. And then if it is a complaint that requires, larger compensation and things like that, then they could go to the consumer court. So this is an option that is available to
Yeah, but
consumers.
most people don't know about that, right?
Yeah, that is true. Also, you see the advantage of ombudsman, even, of course, there are complaints about that too. In fact, insurance, IRDA constantly tries to have committees to look at how the insurance ombudsman system is working and constantly trying to improve on it and things like that. And I think there the advantage is, for example, insurance ombudsman, I've looked at it quite closely, not so much the banking. Here I do find that you don't, the advantage is you don't need a lawyer, you just go there and then the insurance company representative comes there and the issues are settled. And I think it's fairly good. As against a consumer court, in fact, one of the biggest complaints I have about consumer courts, which I've written about so many times, I have nothing against lawyers, but the problem is because of the presence of lawyers and the way the consumer justice system is structured, you have lawyers coming there, and then because of that, the whole procedure has become very complicated, and they're constantly asking for adjournments or passover, as they call it, and postponing and then from one adjournment, one date to another, there's a very long gap. So these are all making things very difficult. In fact, I remember in one of those IIPA studies, they looked at the number of complaints each consumer had. I mean, a group of consumers whom they interviewed, a fairly large group, some 6,000, 7,000, and they talked about the kind of problems they had with respect to food or various other things. And then they were asked, so would you go to the consumer court? They said no. 92% said they will not go to the consumer court. Why? They said because the justice system, I mean the procedure is too complicated and it takes too much time.
92%.
Yeah, and they said
That's
it takes
huge.
too much time.
Yeah.
And then they said, in order to win, we have to have a lawyer. We can't fight the case without a lawyer. So which means we are spending so much money. And many of them felt that by the time whatever compensation, and in fact that's another complaint I have about consumer courts, and that is the compensation that they give is, I feel, is not at all commensurate with the suffering that a consumer undergoes, and that is very sad. So many of them say that if you have, when you, the amount that you get as compensation will probably, most of it will go to the lawyer. So you don't get anything. So that is,
You were saying something, Professor Misra, you were saying something about the insurance. You had some example from UK.
you remember? Okay, I was just having a casual talk with you. But anyway, very good. Because I saw in the report, insurance is topping the list. And I still recall in early 2000, I went on a fellowship from British Councils to study the redressal mechanism in UK. And there, one of the sectors was insurance. And the most interesting part I found there was that if a consumer goes to the ombudsman for a mediation, then all the cost involved by the consumer to seek that redressal has to be paid by the service provider, by the insurance company.
So it's like a deterrent, huh?
Yes, in the way that, and this is what I had also recommended to the Ministry of Corporate Affairs, that they should bring it in their mandatory requirement, like they publish the number of data of each company, that how many cases are going to the consumer courts or commissions. Sorry, I don't want to use the word court. Consumer district commission or state commission or national commission, how many are going and what is the cost being incurred by the company towards that litigation. That should be reflected in the annual report. The whole idea was that, and I'm trying to tell IRD also to implement that, and they have already agreed, but there is a lot of resistance from the insurance companies to not make that happen. But then I'm just waiting when I'll hear it's not going to happen. Then I will raise my voice. Today, at least, they are thinking about it and talking about it, because I had given that idea from UK, and even Citizens Charter, which we started a campaign in India to develop the minimum standards, voluntary standards, was actually a copy of what was being done in UK. So, I mean, there are mechanisms where you can make it deterrent and really ensure that it is so deterrent that the service provider will dare not do it again. Because the board will, actually reprimand the CEO that why so many complaints are going before the
So,
judicial system.
one of the things, I mean, we spoke about this silo-like approach, and one of the things that really, is affecting us today in this silo-like approach is data privacy. Anywhere you go to buy any product, go to any service provider, the first thing they ask you for is number, and that number you don't know who it, where it goes, whether it's how it's used, misused, etc. Now, shouldn't be also that, part of an integral consumer protection system? I'm asking you, Professor Misra.
You see, again, it's very unfortunate that the consumer to seek remedies, they have to knock many doors. We have to understand that while a law is being framed, we have to ensure that it doesn't duplicate things. In terms of Data Protection Act, which is already come into force, and things like that, it is paramount, it is important, it's my personal data. You see, if anybody is infringing on that and using it for commercial gain, then either they should share that gain with that consumer whose data they're using. Or at least, they should have the decency to tell that, look, I'm using this data for your interest and giving you a value for that.
Or seek permission.
Consent is absolutely mandatory. You see, like whether it's a clinical trial, whether it's any kind of an, activity which you do in terms of personal protection, you have to seek my consent. And you have to seek my consent in the manner I want it, not in the manner you will dictate.
Right.
It has to be transparent.
Yeah.
In the language I understand. When I went to UK, I saw Citizens Charter made in Telugu, Odia, Bengali. I asked them, what the hell are you doing here? I mean, why are you printing in this language? We have citizens, we have done a study who only know this language. So how do we communicate public services to them? Who doesn't, they make video, they make audio, of course Braille, we know.
Yeah,
but in India, how many publications are there? Right. It's all in English and Hindi. That's all. So,
Pushpaji, you would like to jump in on data protection?
Of course, now we are having, laws on data protection.
But they're so separate. I mean, they're not completely removed from the Consumer Protection Act.
Yeah, that's true. But I think there is the e-commerce rules, consumer protection e-commerce rules, there is some amount of it, but we still need to have more look at data protection much more deeply vis-a-vis consumer protection. I think that's really necessary. There was just one issue that I wanted to raise with regard to, it's slightly different, but the insurance, in fact, your report talks about the highest number of cases pertain to insurance. Now the thing is, the consumer courts are supposed to only look at consumer business complaints, not B2B complaints. Now there is a bar on that. But unfortunately what happened was sometime, and there's a reason for it, because in fact earlier because of certain lacunae in the law, businesses were going and filing cases in respects of services. Goods there was a bar, but services there wasn't, so they were filing. I remember Bombay Dyeing had filed a case before the Consumer Court. Anyway, subsequently the law was amended and that was corrected. But what happened was subsequently some years ago, in a case that came before the NCDRC, I think it was some insurance case, the Commission NCDRC gave a judgment saying that this is not a commercial, taking an insurance is not a commercial activity. And so they allowed insurance cases filed by businesses also to be adjudicated before the consumer courts. And because of that, ever since, if you see, lots of businesses are filing cases against insurance companies before the consumer courts. In fact, I remember at one time I was looking at, I don't know if you have mined that data in terms of insurance cases, but I had, casually while writing on this issue, once I had looked at it, there were so many cases filed by businesses in respect to insurance, and that has to be plugged. The law needs to be amended to ensure that this does not happen. Of course, because the Supreme Court and the NCDRC gave the judgment, That's become an issue as of now.
Professor Misra, you
No,
want
I just wanted to add, what came in was actually, it was defined, like, for example, I own a truck for commercial work, and my livelihood is dependent on that. And because my livelihood is dependent on that, the Supreme Court intervened and said, yes, it can be heard as a consumer case because his livelihood is surviving on that. So it's not actually fully a commercial activity, it's a self-employment. So like a lady buying a sewing machine, I still recall, it was not being allowed because she was stitching garments. But then it went up to the Supreme Court and she was allowed to, claim compensation as a consumer. Now, I don't know actually how many are of them, but I definitely know that insurance is highest because.
So let me tell you data from the report. Banking plus insurance plus finance, and by finance I think it means stock market, etc. It's totals up to 40% of all complaints.
And all three are services.
All three are just services, right?
Yeah.
And then you have a significant and persisting number of complaints against housing companies, medical service providers, electricity suppliers, right, for wrongful billing, etc. And the report, let me quote from the report. Report states that, within quotes, the frequency suggests delayed services, defective products, denied claims, and a refusal to accept responsibility. And there is repetitive behavior. So, there is some element of brazenness in this, right? So I'll just stop here and maybe open up the floor to questions and answers. The first, Mr. Divyajyoti Jaipuria. Yeah, he wants to ask a question. Can you introduce yourself, please?
Thank you. I am Divyajyoti Jaipuria. I am the President, Consumer Commission, District Consumer Commission, North Delhi. Three things I would just like to add. One is that you talked about the Supreme Court judgment about the insurance cases, NCDRC case. That case is now been Harsolia Motors. That has now been upheld by the Supreme Court also, and Supreme Court also said that insurance cases are not commercial in nature, and therefore even the commercial companies, even they are buying insurance, they can also come to the consumer commissions.
Contract of indemnity.
Correct. Correct. So that thing Harsolia Motors that now has been upheld by the Supreme Court as well. So it's a general law now that even the commercial cases, we are also dealing with cases, consumer cases filed by the companies. Insurance claims and all. Second thing that I would also like to add that the quality of cases that has now that are now coming to the consumer commissions, it has now changed very widely. When 86 Act was passed, it was thought that cases like consumer goods and all those things would be coming in the consumer commissions, but nowadays most of the cases which are coming off are related to service sectors. Insurance is one of the largest volume of the cases in the consumer commissions are coming from the insurance sector largely. Then medical negligence cases are also there. Banking cases, cases against banks are also there. So now the quality of cases has now changed in the consumer commissions as well. Second, another thing that I would also like to add is that you talked about the 90 days timeline in the Consumer Act that consumer commissions are required to finish the cases in 90 days time. I'm working in the consumer commissions. I have been the president of consumer commission in the last 9 years, and I know that how consumer commission functions. Even under the act, if you see, 90 days period is not realistic. When you file a consumer case, there is a guide, it requires that within 14 days you have to issue notice. If it's not issued, notice is not issued, it is deemed admission. So once from filing case, from the first hearing, it usually takes 7 to 10 days. Yeah. So then when you issue notice, at least 21 days time you have to give for service of the notice. So then even the Consumer Protection Act also says that when the notice is served, the opposite party gets 45 days, the maximum days, time period of 45 days for filing a reply. When the reply has come, then 15 days time at least you would give to file rejoinder and evidence to the complainant, and then another 15 days to the opposite party to file their reply. And this is the minimum time period that you can give. And this only comes to 96 days. And here only, I am not calculating the date for the final argument. It is only for completing the procedure of filing, completing the pleadings. So 96 days is the minimum time that you require for completion of pleading, and the Act says 90 days timeline. That is completely unrealistic, and this calculation has to be understood by everyone. Second thing, then, when you talk about that, the cases which are being disposed of in 90 days, around some of the states, they are having disposal in 90 days also. But I would say that if you see this calculation, all those cases, if you see the quality of orders in those cases where the disposal rate is in 90 days, these cases must be cases where the cases have been disposed of or dismissed at the time of admission itself. So 90-95% of these cases are dismissal cases, and remaining cases are the cases which are settled. Within the first 2 hearings, these are settled with the other parties. So these cases are not the cases which are decided on merits. So if you see that disposal rate is higher, say within 90 days time period, this means that these are only dismissal cases or settled cases. These are not decided on merits. So that does not reflect the actual functioning of the Consumer Commission, because dismissal of the case is very easy. So on the first hearing, the Commission finds that it is not a fit case, dismissed. So that does not show the actual functioning of the Consumer Commissions.
Can you keep this short? I mean, this is
yes,
now we want others also to ask questions.
Yes.
So we are short of time. If you can just make it brief, please.
Just one more thing that I am also. I'm only pointing out some of the things which are required changes in the Act. One thing that I would also like to add here is that district commissions can have more than 2 members also, up to 10 members they can have. But once you cannot have benches in the district commissions, you cannot have higher disposal. Act says that you can have more than 2 members, up to 10 members in the district commissions, but Act also says that the bench would constitute only when the president is part of the bench. So even if you are having 10 members, you can have only one bench. So unless and until you make some changes in the Act or in the rules, so that you can have multiple benches even in the district commission, you cannot multiply the disposal rate.
Thank you.
If I may just add
one point.
point
Want
to
to respond?
Yeah, one is when I talk about the statistics about 90 days, I assume I'm taking it from studies. So I assume they have taken, the number of days that you are mentioning into consideration when they talk about the number of cases decided within 90 days. And the other is, for a long period I've been arguing against this admission itself, because 1986 law initially did not provide for admission of the cases. Now this process of admission itself takes so much time. Now, of course, under the law, maximum 21 days, if they don't do it, then it will be considered as admitted. But I still feel, this is not, a civil court. Why should we have this system of admission? Because earlier there was no such system. It was, the court would look at the complaint and say, okay, yes, this is taken in. So I really feel that that's a waste of time.
Can we have some more questions from the floor? Yeah, there's a hand at the back there. Please introduce yourself.
Hello. Good evening, sir. I am Manoj Kumar, a farmer and a lawyer now. So I want to ask one thing, but when we say the consumer justice, first thing is consumer protection. And in consumer protection, we see many fields where there is no rules prescribed, like the pesticide industry you see. If I buy any pesticide, that it will act or not act. The organic food we consume, that it is organic or not, there are no standards. If not standards, then the consumer justice and the commissioners have no syllabus to work on, that what they will look for. What do you think about that?
Any specific person you want to reply to that question?
So anyone, if...
Okay. Who wants to take it?
No, in fact, we did a study, and as you said very correctly, what the consumer looks for, if you ask them what are the top 8 expectations of a consumer, the first top comes is standard. Now, many are today in our country products and service which has a standard, which is mandatory as per law, or there is a voluntary standard which needs to be adopted, developed by BIS or other regulatory bodies. So as you are very correct, no product or service should come into the marketplace without a standard. That is very, very important, because if there is no standard, then how would you make that product or service accountable? And how would you give a resolution in terms of compensation or an unfair trade practice? You have to bring a standard. That is mandatory. That's the first thing. So I agree with you very much. Very good. You raised a very good question.
There are many lawyers in this room. But there are some more hands. So, we'd like to hear from lawyers also. Srini is raising a hand there.
Sanjay.
I can't see.
Sanjay,
Okay.
Sanjay Chadda.
So let's get that first, yeah.
I'm afraid I'm not a lawyer, I'm a journalist. I wanted to ask what can be done to make the companies, the providers of goods and services, take the Consumer Protection Act more seriously. Right now, they see it as a small nuisance. All of them have lawyers on payroll, so they just throw the lawyers, and it's a very passing expense. They don't really see it as something which they need to comply with seriously. They don't see it as a deterrent. So, what needs to be done to first of all make these goods and service providers take this consumer redressal system a little more seriously?
Please, he has a point.
Yeah, in fact, I have been talking about this right from the time I got involved in 1980. You are absolutely right. And the only way it can happen is to ensure that any litigation or any dispute which is not resolved by the company, all expenditure incurred to give a resolution to the consumer has to be paid by the company or the service provider. Then only it will become deterrent. And I gave an example of insurance ombudsman in the UK. And we are trying to do that in India. I don't know whether we will be successful, but I'm trying to convince the government, I'm trying to convince the policymakers, the lawmakers, that you have to bring in a law where all expenses incurred by the consumer to get a resolution has to be paid by the service provider or the manufacturer. Simple. That's my take.
Pushpa, do you want to say?
I would just add that one, the compensation, in the consumer courts will have to be really steep so as to make the business stand up and kind of, realize that, we can't get away with this kind of violations. I think that's very important. And also, of course, I do feel that in many countries, it is mandatory for businesses to provide a proper independent redress agency, like say an ombudsman. I think that should become mandatory instead of putting all the load on consumer courts. Why can't manufacturers take responsibility for the products and the services they provide, which they're not doing? In fact, in North America, for example, the Better Business Bureau, they actually provide consumers with an impartial system of mediation, if not arbitration. And those manufacturers and service providers who do not respond positively to that, they get their ranking goes down, and then there are remarks, it has certain repercussions. So in fact, for a number of years, I've been saying, why can't our manufacturers, our businesses, take responsibility for the products and services that they produce? I think that is absolutely necessary.
Want to add what is coming out of the report, that brand reputation is extremely important to brands who are serious. And if this data was available, like we have tried to make this data available on the entities within the system out of the 29 lakh cases. So if there was a transparent system, then the brand reputation will itself drive a lot of companies to become more responsible. So the deterrence could come in other ways. The tiger may not get suddenly a lot of teeth, but there are other ways to make the tiger
responsive, yeah. So, I agree with you, but that data, correlating the number of complaints with the data, how do you get that? Where is that data available?
Yeah, it is not, but we have to mine it. So, we'll do our bit. But as I think Justice Lokur said, that this should all be done by the government themselves.
Right, fair point.
In fact, the law very clearly says that the government can also represent the consumers and go before the district commission, state commission, and national commission. Not a single case has happened where government has gone on behalf of the consumers. There was one case which happened in Ramvilas Paswan's time on Maggi noodle. Yeah, that's right.
Right.
So, and then because of wrong filing and all that, it got dismissed. Yeah. So, I mean, it got withdrawn.
There's a question here. Can we get mic here, please? Here. It's on, I think. Sorry.
Thank you. My name is Sanjay K. Chadda. I'm a lawyer, and I've been primarily doing practice in the field, the Consumer Protection Act. There are 2-3 things which are very, very serious. Sometime I find that one, the court reserve orders, and years have passed, no orders are passed. Final hearing happened after 4-5 years, whatever. Then court reserves order, and no order is passed for years together. That is one problem which we see. Then, as earlier law used to mention that the matter has to be decided within 100 days, which we have seen what my friend has said. Yeah, but now there is another judgment. Sometime what is happening, there is a judgment of Supreme Court which says that within 45 days the reply has to be filed. And if not filed, no opportunity will be given to the opposite party. So that, if there is another, I have seen myself, there are various reasons like the complaint copy is not provided. How, without having the copy of the complaint, one can file the reply. So there are many things, but it is the order of the Supreme Court, so we have to follow, all of us. The most important thing, which I feel the entire burden will be reduced by, I think, 40 to 50% if we have a very serious pre-mediation is there. Every case should go through, pass through the mediation process first. And there, and if it is happening, I feel half of the burden will go. But if I tell you today's state of affairs, none of the courts have the mediators. None of the court. If only those mediators are there which are appointed by the court and which have been paid by the parties. Both the parties have to pay. So that is very, very important that we should have a pre-mediation. As in many laws, we have seen there is now that one act is there under which before anything, you have to first go to mediate. So these things are very practical things. And the bigger thing, of course, as stated, that long dates are given at national level, state level. You know, even we have already received dates for the next year. You could see where is the 100 days goes. Right. So 1 year date has already been given in many. 2027 calendar is already started for many of the people who are regularly doing practice.
Thank you.
Thank you very much.
So there's one hand behind.
I don't know something what he actually said. I will just answer.
No.
So those were absolutely valid points. I'm Abhishek Yadav. I'm a practicing lawyer in New Delhi. I have one simple question, or maybe I would like to seek an opinion with respect to the execution of the orders. So 5 years have gone by, people are just fighting, finally won, and what about the execution then? Because it becomes really difficult as a consumer and as lawyers also to instill that confidence in the consumer that no worries, it is not just a paper award or an order, you will get what you deserve.
So taking all of this, I'm going to ask the last question to all of you, 1 minute each. It has been suggested that, you know, one way out of this is probably introducing class action suits, you know, with really punitive measures included. Do you think that's going to help? Just quickly. Quickly.
I've gone on several PILs I've done. And in fact, if you ask about me in ChatGPT, you will say he's the most litigant person in the country. So my bottom line is what I'm trying to tell you all is that, yes, it will. And that is why the government has been given powers within the law to go on behalf of the consumers as on a class action litigation.
Yeah. Yeah, thank you. So I'm going to, sorry, Pushpaji, you want to last word?
No, I
just 1 minute, quickly.
Class action in cases where, you know, a large number of people are affected, yeah, certainly that would help. But in most of these cases, it's all individual consumers who have
Because we don't know, because the
there.
same product may be affecting me.
Yeah, you know, in fact, CCPA also has the power now to, that is the Central Consumer Protection Authority, also has the power to, you know, take up these kind of issues pertaining to consumers as a class.
Okay, thank you. Sorry, I have to cut it short. We have the chief guest waiting for us. So let me call the, bring this to a close. Thank you so much, everybody.
Before, I just want to congratulate you all for the wonderful report that you've brought out. And it's going to really help, I think, the policymakers, the government, and consumers also. And so it's an excellent report and excellent idea that you came up with this. Thank you so much.
Thank you. I think some lawyer questions will be best answered by our chief guest. And I want to just thank Rajrishi ji for doing this for us. Thank you.
We now come to the final session for this evening. May I request the volunteers to please clear the chairs on the stage. It's an honor to invite Justice Sanjay Kishan Kaul, sir, to deliver the keynote address for the Consumer Justice Report 2026. Please, sir, welcome.
Very good evening to all of you, Justice Lokas, Mrs. Daruwala, and all the organizers and the people present here. I browsed through the report. I saw the discussions which were going on here, and I wondered whether the title should have been different. Is it a consumer justice report or an injustice report, is what emerges. See, let's understand firstly why this act was brought in. It was it's a public friendly act. Parliament debated it, 86, subsequently amended. Now, my belief, not in this, but any of these acts where these problems are arising, is that the executive owes the duty to give effect to the mandate of the Parliament. A legislation is a mandate of the Parliament. Now, does it only mean that once the act is passed, the chapter is over? No, that's where the role of the executive kicks in. And there are various steps to be taken. Rules are framed, then you constitute members. You decide how many members State Commission, District Commission, National Commission should hold. So this is an expectation of how much litigation will be generated. And there has to be a constant process of review. That review requires that what is the legislative impact of this legislation. If it requires more members, then please increase the members. But forget the increase of members, we are having a 40% discapacity. Now, if the very people who have to decide are not there, how is the remedy to be provided? When that man or woman comes as a presiding officer, he does not come alone. He has the requirement of a staff, he has the requirement of a space, he has the requirement of facilities, computers, etc. So it's a package deal, and this is not only Consumer Act. we've, Lokur and I sitting in the Supreme Court right till, found that in many such places with RTI Act, Consumer Act, these are all specific legislations, including judicial appointments, including High Court judicial appointments, which I've been a party and trying to press, that unless you have at least the sanction strength, where is the question of increase of strength which will come up. High Courts also operate at about 70% of the sanction strength, where the areas are so much. And frankly, the COVID times have produced a very huge setback to all judicial and forums of this nature also, and we've not been able to recover out of it. In fact, that's why the example given of a date in 2027, I'm surprised in the Consumer Act, but it is, if one of the councils is saying so, maybe so. I was both just looking and I was very surprised when I said that this problem of orders not being pronounced permeates the consumer forum also. Again, very surprising. It does happen in some judicial areas, and the Supreme Court had come down very heavily on it, where the High Courts are expected to give a judgment in the maximum period of 6 months. Actually 3 months, and then ability to mention, etc. Consumer forum, which is something which is to be given as of yesterday, it is important that the matters is decided earlier. But if every member or committee has 100 cases before it, how do you expect things to be decided? So there has to be a study as to how many, ideally a number of cases can a bench decide. And then bench creations must be there, keeping in mind the task before the bench. So one, areas. Number two, the future flow of litigation. All these are aspects which need to be considered. Infrastructure also, if I may flag, is inadequate in most places. This is true of everything. Sitting with the then Chief Justice, I was party to the bench. We had issued notice to all High Courts for judicial appointments, subordinate judges' appointments. And we found that every state there was absence of exams being held, of infrastructure being created, of housing for subordinate judicial officer, of stenos, of infrastructure. This is a package which has to come. It can't be individually, you can't expect something out of the extraordinary if there's no support system in picture. One of the issues thought was of gender. It's an important issue which comes in always. Let me say my experience in the last couple of years before demitting office was that in competitive judicial examinations at subordinate judges level, most states, without any reservation, women account for more than 1/3. I have travelled to Patna as a judge of the Supreme Court. I have travelled to Tamil Nadu, to Punjab, to many other states. That's the benchmark there. If at the higher judicial levels you don't have enough women, the reason is simple, that you need lawyers of a certain age profile, and at that time women were not continuing to be members of the bar, so it will take a little time. This act, by its very nature, certain areas were such that the women would possibly know better, because they are the consumers in many areas. May not be for the insurance sector, may not be for the medical sector, but and it is not difficult to get women to be occupying these posts. What is the problem, whether men or women, according to me? Don't make it a patronage. If it's a patronage, then you may appoint as many numbers as you want, you may appoint whoever you want, you're not going to get results. It must be people who understand the nuances of consumer law, and there must be also people who are willing to work and serve. So this is another aspect which arises for consideration. Now, some area where I am in divergence with the members who spoke, and which I am very passionate about, is mediation. Let me try to spend a little time to understand why I say so. Both Justice Lokur and I have been propagandists of this method of resolution of dispute in the court systems. There are mediations annexed to the court system, there are mediations away from the court system. In fact, we thought it was of such importance that when I was in the Supreme Court, the mediation committee headed by Justice Lokur, with myself and Justice Indu Malhotra as members, and Justice Narasimha as a lawyer member, asked the mediators through the country to draft a central mediation legislation. This was COVID times. They met through different things and prepared a draft. We as a committee members vetted the draft of the mediation, because by then from earlier nuance of the government thinking that separate mediations in separate acts is what is there. They were slowly veering route to a centralized mediation act, more so in view of signing the Singapore Convention in 2019. So after vetting it, this was the act, a draft, let's say a proposal or a suggestion, which on the administrative side went to the government. As usual, it lay there for a year and a half, and suddenly then someday the government woke up and said, we want to do. They brought in an act, substantively a central act, contains many provisions out of that. Where a major difference is, which can't be avoided, we had thought of a non-government controlled system. Government always likes a government controlled system, so that was one of the major changes which was done. Why I say mediation? Because the experience of nations and developed nations which have operated different enactments and quick disposal of disputes, mediation has played a very important role. Both of us, Lokur and I, had the opportunity to travel to the US under a justice exchange program in 2000s. My personal experience was I like to do it. How were they doing it? One was, of course, that the system of court management was something which was excellent and which permeated this. Second was that about in California, which bore a large brunt where we studied, 97% plus cases went through an alternative dispute resolution mechanism. So 3% cases went to trial. You could manage them. If every case has to go through a judgment and an appeal and a second appeal, then no system can work, and largely in our country's system. We have thus not utilized this potential fully. Delhi has been a great example of it. Sometimes in Bangalore has been there, but some of the other commercial cities have also not come up with it. Why I say here mediation can work? Of course, there is a pre-litigation mediation. What are the alternatives? We are looking to a jammed system. Yes, ideally, consumer complaint filed, it is decided, say, even let's take it 6 months, no problems. But when it is not moving, what is the alternative? The consumer needs a remedy now, 3 months, 4 months hence. If there's a medical negligence case, he wants a solution now. He needs the money now. What is the point of giving to him after 10 years? So, apart from a better methodology, leaving less of acrimony, there is also an issue of easing the systems. Like if you have, let's say, why do you create a bypass in the heart? You create because of the blood pumping. You are creating a bypass in the system so that there are alternative methods to resolve. Some of them are small issues, and I believe if there is a structured mediation, which is there are mediators available annexed to the court, and you can go to the mediators, most parties would like to settle. Let's look at it from the opposite corporate side. Would they like a judgment where the name is played up, or would they rather like to pay up something and finish off? I believe the second is a better alternative for them, not to drag their name in. Linked to this actually is a cost system, which is worked there. So if you litigate from the lowest court to the highest court, the cost becomes so heavy that it becomes punitive itself. It doesn't happen in our system. This was one issue raised. If the alternative is to pay actual cost, it will not make economic sense for somebody who is guilty of deficiency of services to litigate if he can settle this account. So that's the reason I feel mediation can play an important role, but you have to have a structured system. You must have enough mediators to look at it, promptly give a report whether it's settling or not. Because the fear of the litigant is that here I have come to one forum, now I'm being shunted to another forum. How will it work it out? Well, that confidence has to be there. Look, here you will mutually resolve. It's a confidential system. You don't have to disclose why you are settling. You can say things in mediation which you will not be able to say in litigation, where you will be able to accept what you really want and the other side accept what really a mistake has committed, because it is confidential. So you can possibly resolve some of the disputes. I do believe in mediation in a better way. Now, how will this system work if, as I said, the first issue flagged is the number of people working the system. This, I don't know why the government, having created a methodology of redressal of disputes, and let me say there are no political cases involved here. So they should be more than willing to see that there are some areas of litigation which should be tackled at hand. Some way I think the public momentum has also to play a role. Consumers who are affected must be able to join together in a system to play a role to make the government realize that, if I might use the word, that it's politically expedient to see that the people get the remedy early, and inexpedient if the voter doesn't get his remedy in a fixed period of time. So some people's movement is also necessary. While I was reading the report, I don't know, I was told by then that this is correct. The example was given on page 33 of how many posts exist, how many vacancies exist. One aspect stared in me the face, so somebody from the committee can confirm it. I was confirmed to me that the number of posts went down in 2025 from 10 to 4 in Uttar Pradesh. It's a huge state. You mentioned that it is correct. And the vacancies were still 25% there. That means 3 out of the 4 posts are only manned. Many places, chairmen are not being manned. So even if you have members, sittings cannot take place. Now, this is something which is unacceptable. Which means that whatever effort we had made in the Supreme Court a couple of years back, where we had issued notices to all states, asked them to fill the vacancies, do this, but it was a constant monitoring going on. I really don't know the fate of it for the last 2 years, but at least our bench used to put it every 2-3 months to see how many have been filled in, what is the impediment, why are they not being filled in. The example which recently I saw got played up was, well, there are some small states, there is no need to appoint. There are no disputes. Okay, that may be fine, don't appoint. Have some other system, but where they exist, at least appoint. See what is the areas which are pending and then appoint. That unfortunately doesn't happen. Also, we have an appellate structure, appeals going further. One of the things I was discussing here was, and you can think for the future to examine, is we did it in the High Court when Justice A.P. Shah was the Chief Justice, to flag cases which are pending from date of origination. See, where appeals are there, for a litigant, it's a cradle to grave philosophy. When does he get to court and when does the matter end? So suppose an appeal, it has come up a year earlier, but the first level forum has taken 6 years. Then the case is 7 years old. It's not 1 year old. This is another aspect, I think, which needs flagging and understanding, that we must give some priority or some method of flagging the origination of the dispute. Another aspect, of course, which was said was of the execution. Now, this is the old story always, that we say that the second round starts in execution. Civil court executions go on for ages. In a civil court, the oldest execution I dealt with was 47 years old. From the date of origination of the case, if you see. Not from the date of execution, but from origination. So I told them this has to finish one way or other, whatever may happen. I normally don't issue time-bound directions, I did that, saying it can't go on. But consumer forums are smaller in issue, so there should not be any problem in deciding the issue. If there's clarity in the judgment itself, I see no problem in execution. Somebody recently discussed a case with me, and I thought it was odd that the execution issue is pending and somebody in execution is trying to now interpret what that order meant. This is not the role. I can't give an example because it's a sitting litigation, so I can't do it. But I thought at least the approach of the forum was not correct in the way they were going about it. Now, for enforcement of orders, there is, of course, that's Section 71 of the 2019 Act, which is there, and it can be enforced as a decree of the court. By looking into, I found, in 1872, in a judgment of the Privy Council, it was said the difficulties of a litigant in India begin when he has obtained a decree. So the problem has not been solved since 1872. It's a long journey for most areas to be done. The delays, of course, create the whole problem. There is also a Consumer Protection Authority under the 2019 Act. And the purpose is to regulate matters relating to violation of rights of consumers, unfair trade practices. It has supposed to have investigative wing under the Section 15. Has powers to sumo to inquire into allegation violations, recall goods, direct reimbursement, penalize false misleading advertising. The scope is wide. The scope is wide so that what was being mentioned as class action litigation really can be dealt with if an active role is played by the Consumer Protection Authority. I don't know really how much is being done. I am told that practically nothing is being done. So why the Consumer Protection Authority? The government was supposed to play a consumer-friendly role through this authority. You must have also in these authorities people who understand and empathize with the consumer. Unless that happens, if it is only a vestige of accommodating people, I often say, there are many judicial forums and other tribunals which have slowly become only a method of accommodating retired judges, retired bureaucrats to do a particular thing without any also testing of inclination to do the subject. This is not, it's unlike a very, very technical jurisdiction. This is not so the Consumer Protection Act. Somebody can read it and implement it. So what is important here is a commitment which is necessary for that person to carry it forth. At least that will give a push. Of course, what has been discussed is some of the amendments which is required to be considered. I think it's time to explore global practices, what is happening, how they are done better, and lobby and make sure that the government, at least to the extent the structure is provided under this act, make sure that what is missing is filled. So amendment is the next stage, but at least the first principle is why are members not in place? Now, if you see the performance I saw, I asked, Jharkhand is not a big state, but in performance, why does it come so low? So I was told 5 years there was no chairman. This is unacceptable. And somewhere the courts, if the Supreme Court has to be knocked, it has to be knocked. I know Supreme Court, we also used to get fed up of this matters coming because we thought this is the job of the executive. But if the executive doesn't do its job, then you are generating litigation which comes here. You have creation of pendency of litigation. And I'm sure if they are knocked and there is, I don't know whether that litigation is still pending for monitoring or direction, something I think can be hoped in terms of what can be done within that time. I was trying to see, I'm bad at names, whether I remember, I'll recollect and say where it was being done. But some monitoring, I think, is required and is necessary. A wonderful effort, let me say, has been made in preparing this report. But does this report have to be on a piece of paper only is the issue which will arise. See, unless you take steps to see that this report is implemented, understood, appreciated, and dealt with by the government, it will be a nice report to read, but it will not be able to get the results. To get the results, the executive has to be prodded, cajoled to see that they read the report and seek how to implement the report. That's most important. In fact, I don't know, I'm not suggesting anything I can't, but in judicial proceedings relating to, say, appointment or others, it can be pointed out that this is an independent analysis based on government data, as was pointed out by Mrs. Daruwala in the beginning. We are not looking to private. It's the government data, as much as was available, itself shows the position. I think if the concerned authorities and the highest judicial authorities go through this report, and I have no doubt they should go, the burden is on all of you to push this ahead and see that the next step of implementation take place and this doesn't remain with dust on the shelves. Thank you very much.
Thank you so much, sir. Your address, including the alternate title of the report suggested by you, I think greatly captured the urgency and the depth of the challenges that we face in consumer justice, and reminded us, I think, why strengthening of these institutions is so critical, and such reports are also always timely, I believe. Now, before we wrap up today's evening, I would like to request my colleague Shreehari Paliath to deliver the formal vote of thanks. Thank you.
Good evening, everyone. My name is Shreehari Paliath. I am one of the researchers of this report. It's my privilege to propose the vote of thanks on behalf of the India Justice Report. First and foremost, I express my deepest gratitude to Justice Sanjay Kaul for his presence and extending his support by delivering the keynote address tonight. A profound appreciation for your valuable perspectives on consumer protection and institutional capacity, sir. The IJR is immensely thankful to Justice Madan Lokur for his constant and continued support and encouragement over the years. We also take this opportunity to thank our distinguished panelists for their time and sharing their expert views on consumer redressal. I'm certain all of us present today have benefited from their experience and observation significantly. As always, we convey our gratitude to our steering committee and funders for their support. We thank Debashish Ray for his guidance and advice on communication and dissemination. I also take this opportunity to thank Avinash Singh and his team at How India Lives, who are our constant data partners, and to Rishabh Mehta and Faris Ansari of Frappe for developing the website and advising on all matters tech. Finally, and most importantly, I would like to convey my deepest gratitude and thanks to our small but power-packed team at IJR. Thank you, Maja and Valay, for your constant support and ensuring that the IJR is held to the highest standards. A big shout out and thanks to Nanika, Soumya, Sarab, Dipul, Bharat, Yash, Ajay, and of course Siddharth, the lead researcher of this report. They put in long hours into creating and presenting the report and making today's event a success. Once again, thank you all for your attendance tonight. I now request you all to join us for dinner. Thank you all.